This conference will now be recorded.
Okay, thank you. Thanks for joining the call today. This is part two of our product liability risk control. Today we'll focus on product liability risk that really covers like civil, potentially criminal, legal implications, and that's why we have Adam here. So we'll talk about the current signs and trends, and really indications in the cannabis space that are tied to the product liability risk. So good morning and good afternoon, good evening. I'm Bethany Carney, and I'll be acting as like the host for this call. So I have you all placed on mute, and I'll continue to do that. But of course, if you have comments or have questions that come up during the conversation, please shoot me a comment in the chat. And after John and Adam share information with us, we'll have plenty of time for discussions where I'll unmute all of you. And I encourage your participation in that discussion so that we can make sure that this topic is relevant for you and your organizations. I'm going to start here with the introductions of our presenters on the call today. John Malavey is the CEO of QA Canna. QA Canna is a quality assurance consulting firm that was established to solve complex problems in the cannabis space and help execute critical projects across the industry. Adam, who's new here with us at QA Canna, is a tested litigator and multifaceted in a multifaceted legal practice, Goldberg Segalla, and he heads the cannabis and hemp law group. So while he's also defending clients in a wide range of claims. Goldberg Segalla has an international footprint, although they're headquartered here in the US. They have over 400 attorneys in their practice. So thank you, gentlemen, for participating today and joining us and bringing your expertise to this discussion.
Glad to be here.
So John's going to kick us off with a brief recap from our part one session of product liability. We're going to talk through the appropriate response for customer complaints. We'll go through some guidance on product claims and warranty of merchantability, and end the discussion here today with what we're defining as the true risks of liability for our customers and a few case studies that Adam has discussed with us to really support this. So John, if you wouldn't mind kicking us off here to run through what we discussed in part one, that'd be great. Thanks.
Sure, thanks Bethany. And Adam, thanks for joining our call today. Really appreciate the time and the insight that you will be providing to everyone. So going back, I first would invite anybody, I'm just gonna go over some bullet points of what we went over in part one, which was insurance related, but I invite everyone to just go onto the website if they wanted to, and they can download a webinar version or even a podcast version of part one to give you a better understanding of what we discussed in part one if you weren't present, and how it ties into what we're gonna be discussing today. But some of the high overviewing points that we went over were the needs for types of commercial policies to protect companies and the public users, and how insurance companies develop them and define them, and then obviously deliver them to potential customers. Specifically, we kind of focused in on product liability policies and what they cover, things like illness and side effects, or lawsuits from illnesses and side effects, and then also like product malfunctions and defects and things like that. And that's how we kind of abutted against the scope of the legal aspects of product liability outside of just what the insurance companies are providing as protection from a business perspective to prospective clients. Currently, the industry provides insurance policies, but only via, like, I forget what they're called, but like not third party, smaller regional carriers rather than, you know, the big carriers, the big companies. And you know, that comes with a lot of exclusions and excessive costs because they really don't understand the industry per se. And the regulations are rather weak right now. So due to the new industry, as I was just saying, there's not a lot of understanding about the risks that the industry currently presents to end users, to patients, and also to company owners themselves. A lot of times from our interactions, people will think because they've been in the cannabis space, illegally or legally for some period of time previous, that they really understand risks, but that's really not the case. They don't really understand the products from an objective scientific perspective, or the processes, or any other aspect of the product life cycle. So that means that the risks aren't really understood. So the insurance companies don't really understand those risks because they're not really identified and brought to light. And then also there's supply chain throughout. I mean, there's risk to the supply chain throughout the whole product manufacturing, whether it's raw materials and ingredients that a company obtains to be able to produce a product, and then all the way through manufacturing and then through distribution. We talked about risk all throughout there, and how insurance companies understand it on a very limited basis, but with further understanding, it gives further risk management principles that can be applied to their practices, and then also to the license owners and the product owners' practices. But I think the main point that really came out of the whole discussion was insurance is not a substitute for manufacturing a quality product. And that's why entities like QA Canna are still relevant and still robust, even within mature industries that are decades old, because you need to have this strong quality insight and understanding of principles and practices to ensure that you're making a quality product and that your operation is running in a quality manner, because it's not just about the monetary liabilities that you might be presented as a product owner, but then there's also potential criminal aspects, or legal aspects that even cover monetary from a civil perspective. And that's really where we segue into this part two, and why we felt it was imperative that we had a part two, because it's really this whole other realm of an insurance company can protect companies to some level, but really there's a lot of other legal implications that are probably far more damaging and at risk, or puts companies at risk of those types of repercussions.
Thank you, John. I wanted to jump into our first topic next. This is really where the initial reports from customers start. And John, it's not to put you on the spot again, I wanted you to really offer some historical perspective as we start out here, to talk about the appropriate measures that companies should really put in place to manage customer complaints.
So, I think what we always emphasize from a quality assurance perspective is not quality control, which is a reactive process, although that's obviously a very important element of quality, but really being proactive, understanding and identifying risks throughout your operations, and mitigating them or eliminating them if possible, is imperative to having a successful business in a regulated industry. And along with that, through those practices, you get a better understanding of your products and your product risks and your processes and your process risks. And, like we were saying before, your supply chain risks. Those are all elements of objectively evaluating all the systems and practices within your operation, and assessing them properly and saying, okay, these are the risks that we have, that we know whether they're required to be identified by law or not. These are the risks that we know. How can we best go about mitigating them or eliminating those risks, and increase process efficiency and product efficacy and things like that? Those are all critical elements that we look for as outputs within our practices.
Thanks. And I guess we'll just jump over to the legal implication piece. Adam, would you mind discussing here what it would mean, I guess, for those customers you've seen who have not taken those appropriate measures?
Sure. So I'll keep my focus mostly with a New York kind of frame of mind. Obviously, I'm based in New York. Products liability law can vary somewhat state to state and at the federal level, but we'll keep it focused for now on New York. You have to understand that products liability law, remains, at least in New York, what is a not reasonably safe standard. So products that are dangerous to use in society aren't foreclosed from being used as long as they are reasonably safe. And what that means will depend on the product, its ambit of use and misuse, the steps needed to be taken to make its use reasonably safe, and then the precise factual circumstances in every case. So if you are not, as a company, taking the appropriate measures to address concerns, then you open yourself up to a variety of claims. And in product liability, there are times where you'll see 18, 20 different variations of legal complaints, be it negligence, defective design, breach of warranty, and there are various breach of warranties that can be raised. You open yourself up to all those different claims, and all of those claims have different legal requirements to be proven and to defend against. So if you're not taking the appropriate steps, then you're going to just be reactive. And as John said, you want to be proactive, and you want to make sure you have that quality assurance in place to best, I guess, help defend your company. Because at some point, almost every company will be sued. It's just our nature in this country, unfortunately. It's a litigious society, but if you take the steps necessary to be proactive and set your company up for success, then people like me, when we come in and we look at everything you've done, then we have a better chance of establishing a very strong defense on your behalf.
Adam, so Bethany, if you don't mind, we're going to deviate a little bit here, and I just want to jump in
Sure.
and ask Adam myself, because this discussion can be just so robust. There's just so many things that always come up because, again, like Adam was saying, there's not a lot of precedence within this space. But so Adam, what if an industry like cannabis does not have things like consistent methodologies for testing THC levels or any metabolites or cannabinoids? As we know, it varies from state to state, and there's not really an accepted, harmonized compendial methodology that's utilized or is known as the compendial methodology for testing THC or anything like that. So which leads to this variability. What are the implications of an industry that has those type of variations and nuances that can be rather critical?
Yeah, especially if you're talking about things like hemp-derived CBD. Obviously, everyone, when the Farm Bill passed, although its regulations haven't been finalized, so that's a whole other story. When the Farm Bill passed, there was all these discussions about 0.3% THC or less. It's considered hemp-derived CBD. It's no longer considered marijuana. You can ship it across state lines, and CBD oils blew up everywhere, and people are shipping them all over, and this, that, and the other. One thing you have to be aware of is, farmers can have their entire crop destroyed if their crop is considered hot, for example. It goes above that level. Well, as you mentioned, different labs can have different testing, compendiums in place and different methodologies in place. And just depending on the lab, you could get different, results. And so you as a company, whatever it is you're producing, if it's THC, if it's CBD products, whatever it might be, if there are going to be claims you make on behalf of that product, the best thing you can do, because there is not a set established methodology for testing that every lab in every state uses, the best thing you can do is test your product multiple times and be able to say, okay, well, we were required by state law to test our product at one of the labs that we have. California, I think, has, north of 25 or 50 labs. It could be in the hundreds at this point. New York only has one, but you want to send your product to as many labs as you can feasibly, economically at least, do it so that you have the evidence and the support to say, this is what I'm claiming my product has or is made up of, and here is the evidence I've used to back that up, and here are the steps I've taken to make sure that what I'm providing to you as my customer is exactly what I say it is.
Yeah, and I think that goes to the point of what I was saying before about having product knowledge and understanding your product, how it behaves, and then also the results that you should be expecting from a process. This is why in industry we we do things like process validations, because with process validation, we expect a certain result. We expect a certain number statistically of passing elements or passing products that are gonna be going through testing and meet some type of specifications. When you don't have product understanding and knowledge like that, it's hard to have an expectation. It's more a reactive process and crossing your fingers and hoping that something's gonna pass. So I think that's pretty critical.
And before we move on to the next topic, I wanted to just touch on a last point. Just keeping in mind that there's fiscal challenges behind this, testing multiple times, and we know there's not really a quality by design process in R&D that's very robust. So the specifications, even though they exist, there may not be a lot of historical knowledge behind them. So knowing these things and like keeping that fiscal challenge in mind. So Adam's defensive measures, and John, what you said about preventive measures. Can you give me a few like take-home key actions, just keeping that in mind, because testing multiple times is not going to go over very well, with a lot of my customers.
Right. No, and that's valid, and that's why when you develop systems and understanding, so quality management systems and understanding processes and things like that, you can impart practices that don't require you to test with multiple labs, which is it's actually not encouraged within the industry. You really want to have confirmatory results, but you don't want to try to test quality into a product. And then say, okay, I'm choosing the better results here, etc. But with better process controls, you can limit your testing. It's really about understanding your product and what the outputs are supposed to be. Now, with respects to something like THC levels and the lack of harmonization to like a compendia methodology or something, those are things that are you're just not going to be able to get around right now, because scientifically you're not going to be able to have that consistency, because scientifically the community is not harmonized in that respect. But that will come eventually, and essentially you can get some element of consistency by working with certain labs and having them, if you can, in your state you can, and having them cross-validate certain methodologies that you might use internally at some point when it's allowed, basically confirming your results from a quality control perspective, then also getting maybe some confirmatory analysis outside by a third-party non-biased lab. But having the same methodologies even internally can eliminate that variability and the I guess the potential that somebody might see you as trying to test quality into a product. You can eliminate that. So I think it's those type of things, and then having control of supply chain and making sure that maybe your supply chain meets certain certification standards or something like that, and incorporating that those are all risk mitigating factors that a company can take on and eliminate the inherent risk that's in this industry right now, just being such a new industry and a new product.
I was going to say documenting everything you've done.
Yep.
Obviously you need to know what the regulations are. If your state says if you're going to make, you have to offer these 3 products of these 3 THC levels, and you offer product A, B, and C, and you have your own internal testing, and you say, okay, my internal testing showed A, B, and C. You've documented all of that, how the testing was done, where it was done, who performed it, how it was performed in a sterile environment, et cetera, et cetera. And then it's required to be sent to an external lab. In New York, we have one. Okay, I've sent it to the lab in New York. Their results came back and matched mine within the acceptable, variable range of, whatever it might be. And this way, you've documented everything so that if someone purchases your product and says, no, it did this, I sent it to this place, you can then turn around and say, I was required as a company to do X, Y, and Z. Not only did I do X, Y, and Z, and here's the proof of it, but I also did A, B, and C. And as long as you have that documentation, it goes a long way to being able to defend against any complaint that a customer might bring against you.
100% agreed.
Yeah, that's an excellent point.
Yep.
Excellent point. So Adam, I wanted you to start off here because this has a really heavy legal connection. So can you provide us an overview where products have been misrepresented and led to a breach of express warranty?
Sure. So there have been times where people will allege that their product is organic, for example, or that it contains this level of, additives or what have you. And one of the things, if you're going to claim your product is organic or it contains X amount of THC and it doesn't, then you're going to open yourself up to a claim of breach of express warranty. So in order to sustain such a claim, what you want to understand is that it requires a couple of elements. First, there has to be a promise made by you as the company to the buyer that relates to the goods, right? So you're claiming to your buyer, you're promising your buyer that your cannabis product is X. It has X amount of THC or what, and that's part of the reason they're purchasing it. It's part of the basis of what we would call in the legal form the bargain. Second, that the plaintiff would also have to prove that any description of your product is made part of the basis of the bargain. Again, I'm selling you an organic type of THC. Well, that's part of the reason you want to buy it. It's organic. It doesn't have anything in it. That's part of the reason they're buying it. And then third, any sample or model that is made part of it. So once that's established, the purchaser must then show that the seller's product fails to conform with the initial description or other statutory requirements, which I'm not going to get into because it'll bore everyone to death and we talk for days on it. But you see those things, and if that occurs, then you've now got a breach of express warranty or a claim for breach of express warranty. And you have to be careful because there are cases out there that support it. And when it occurs, you can't start making claims that your product does this and then it doesn't. It leads to all sorts of, regulatory claims, obviously legal action. You could have, federal agencies come in, send you warning letters, things like that, which I'm sure we'll talk about a little later, but have definitely occurred within this space.
Yeah, we've seen that for sure. That's where we get a lot of our lessons learned and standards set. So bouncing over to you, John, beyond reaching out to legal counsel, what are the companies that you work with doing to ensure that the statements that they're presenting to customers are valid claims?
Yeah, so I think ultimately one of the preventative measures that if money wasn't a concern, I would say for every company to have a regulatory affairs representative or department, but in this time probably just a representative that understands the regulations, not only of the cannabis space, but also the other adjacent industries, dietary supplements, food, drugs, and understanding that dynamic and how those products are established or identified via criteria, and then applying that knowledge to the cannabis space. And the reason being is I think this is, through conversations and through interactions within the space with clients or with just people in the space itself, one of the arguments always made is, why is CBD, why is it not a dietary supplement? Why is it not considered a generally recognized as safe ingredient for food, et cetera, et cetera? And unless they understand these other adjacent code of federal regulations and criteria that are defining these other products, they're not going to really understand the risks, or they might not really understand the risks that they're putting themselves at within this space, because it's just, we don't have that guidance. We don't have the rules, so to say, to be able to follow on how we manufacture properly or how we do these things. So it's really not just about quality, but it's also about understanding the regulations and how they apply from a legal perspective. And that's where you get that tie-in, where legal is directly correlated with regulatory affairs, which is directly correlated with quality assurance in more robust companies.
Yeah, and I guess my next point on this is really for both of you. what companies or who, I guess, is most at risk? And if you could give some thoughts around that.
Well, I think, the companies that are able to basically sustain in this space for a long time that and fly under the radar, they obviously have a larger exposure of their products to the population. But to me, really, it's hard to define exactly because the industry is so vague in a lot of respects right now, especially for something that we categorize as essential within, like, during this pandemic, and really correlate with a lot of the pharmaceuticals and controlled substances in that respect. Those products are so highly scrutinized that a company would never be able to really fly under the radar in the same manner and be able to expose such risk to the population. But currently, this industry it allows that, and I've said it before, and sometimes it's just so egregious some of the things that I've seen done within the space over the years. But companies cut corners, and they do whatever they're mandated to do and are able to do. But unfortunately, they're playing that fine line of being criminally or civilly liable, and then also being able to get away with it and fly under the radar. So to me, that's really the biggest risks, or the biggest.
I would say the companies, like John said, the ones that are a bit more cavalier, or a bit more, I don't want to say reckless, although in some cases it really is a case of recklessness, but the companies that think, oh, well, you know what, everyone's jumping into this space, and I'm not an Acreage, I'm not a Canopy, I'm not a MedMen, I'm not a Curaleaf. I'm just a little company in New York, Massachusetts, wherever you might be. I can probably get away with things, sell my product, keep my costs down, and make some claims that'll bring more people in, and I'm not going to get dinged by anyone because I'm so little and there's so many people out there. And that's really, it's a dangerous mindset to have. John, you and I have talked in the past. There was the former NFL player Turley, I think it was. He has a CBD company and was making claims that CBD could prevent COVID-19 or it would cure it, and he got a warning letter from the FDA, and it just boggles the mind, where people make these claims, and you're not just opening yourself up to these breach of express warranty or breach of implied warranty of merchantability or all these other products claims. You open yourself up to a lot of different claims. I mean, it's, if a lawsuit comes in against you, you may not just get a products case. It may not just have products claims. You could have RICO claims in there. You could have, negligence claims in there. There's a lot that can go into it. It's just, some of those are the companies that I look at as being the ones that are most at risk for these lawsuits. And despite people laughing at times, thinking, "Oh, well, I would never do that." Well, clearly people do, and there's no guarantee that what you put out there won't lead to these criminal penalties. I mean, even just putting a client or a customer, page for customers to post their reviews can lead to warning letters from the FDA. And so, like you said, if you're not aware of these adjacent industry standards, you're running the risk of having your company shut down or having your product pulled. And, that can, just taking it one step further, if all of your product is then seized and you no longer have a viable business and you had investors, well, you've opened yourself up to E&O and D&O lawsuits. So, from a legal perspective, you just see the tentacles, or the branches of a tree just spiraling.
Yeah, that's a great point, Adam. And also to piggyback on that, who knows what type of exposure that provides insurance company, or provides you to insurance companies negating a policy for some various exclusion that they presented in there, that you were negligent, or that you didn't, you were marketing a product that you shouldn't have been marketing. I think the fact that so many people don't even realize that, an ingestible CBD product that's sold on, that you see anywhere. There's thousands of them. They're all illegal. I don't think they really understand that, because as people, we see these products all over and we say it has to be legal. Why? How else could it be sold like this? But unfortunately, this industry for some years now is really sometimes driven by snake oil salesmen, for lack of a better term, because CBD has been purported as the end all be all cure all, and all you need is some parent to give some CBD product to some kid, and the kid dies for whatever the reason, because there's an adulterated product that's contaminated. And I can only imagine what the legal implications could be in a situation like that.
Yeah, and it's interesting because one of the claims you see a lot in products cases are, a breach of implied warranty of merchantability, right? So that's when a product is not fit for the ordinary purposes for which such goods are used, right? So, and there's a UCC, Uniform Commercial Code statute for that, but the basis of it is, a plaintiff can recover when they show that a product was not minimally safe for its expected purpose. And the focus of these types of claims is whether the product meets the expectations for the performance of the product when it's used in the customary, usual, and reasonably foreseeable manners. Well, we're a new industry, so what's a reasonable, usual, and foreseeable manner? And what this type of a claim does is it frees a plaintiff from having to prove a strict products liability case, including proof of reasonable alternative design. So in a breach of implied warranty claim, the inquiry isn't whether or not there was a safer design available. They don't have to do that. It's irrelevant to the merits of this particular claim. A breach of a warranty action depends on a showing of whether the product was not minimally safe for its expected purpose, regardless of whether they could have made a safer product. And so, again, because it's such a young industry, and because people haven't necessarily enacted these quality assurance measures that your company helps them put in, you run the risk of all these different claims. And it really is, there's a lot that you have to do. If you think about what a pharmaceutical company sets up for its quality assurance, that's how you should be approaching this industry.
Yeah, I agree. It's though very cost intensive, resource intensive, and things like that. That's eventually where the industry will be moving. And whether you're a small company or a big company or not, you're going to have to take those measures and establish those systems. So we always, whether biased or not, we always endorse being proactive and phasing those practices in, so you're not slammed at the last minute. But in our opinions as quality professionals, it's better for your overall product and company anyway in the long run.
Thanks, guys. And I want to make sure we move on to the next topics. We have time, but I think that is a really good point as well, because that's from part one. That's a lot of what we talked about in the insurance industry, because they have a lot of experience in similar industries. They're basing a lot of their assessments on those other industries too. So that's a good parallel there, and I appreciate that. We're going to continue on with the risks of liability. Again, legal heavy here. So Adam, I'm going to go back to you. And while we were prepping for this, we talked about a few cases, and what stuck out to me was that there was retailers that were held liable for products that they didn't manufacture. So as a distributor, being held liable, or how can a distributor be held liable for a product they didn't make? And I think exploring that a little bit would help some of our dispensary clients and talking through that a little bit, if you wouldn't mind.
Yeah, product liability law varies state to state, as we said, but unfortunately, everyone in the chain of distribution is potentially a defendant. So that means manufacturers, distributors, suppliers, and the store, the little itty bitty mom and pop shop that may sell a vape pen, right, could potentially all be on the hook. Now, and what may surprise some people is, the fact is from a legal perspective, the plaintiff's attorneys 9 times out of 10 will sue everyone, not because they necessarily think that, Target, for example, is responsible for a defective product, but they're going to sue everyone. One, because they can, and two, because it'd be malpractice if they didn't. So even if you didn't do anything wrong, you've requested all of the testing, requirements, or you've requested all the testing documents from your manufacturer, and you've gotten them, and whatever, you could still be named, and you will likely be named, because if they can't get the manufacturer because they were a fly-by-night company and they went bankrupt, well, then they've got to have somebody to hold accountable, and they're going to try and hold you accountable then as the retailer of it. So, it's not that you won't be able, the non-manufacturer defendants, the retailers won't be able to get out, but, usually what they're going to try and do is they'll try and keep the viable manufacturers in, but if not, and that's something to keep in mind here, especially in this space, you can be named, and you likely will be, and there's a chance you could be kept in the case, and that's almost as expensive sometimes, if not more, than whether any sort of judgment comes down against you.
Well, thanks for those nightmares.
Sorry.
No. I guess, like, going back to like my experience, and I know where John comes from too, we focus, like, in our audits and assessments, we focus a lot on the holder of the license, the licensee. So, like, but of course, you walk through the full supply chain of the product because they're responsible for the product as it moves through the life cycle. So, John, can you offer some insights of what companies can do? And I guess what we're talking about is across the supply chain, to shed some light on those preventive measures for this risk, because now we're seeing as it applies to the full supply chain.
Yeah, so as you were saying, in our past lives, the product owner is really ultimately responsible, and it's why regulations and standards basically demand that you have a supply chain that's qualified, essentially going through a supplier qualification process, understanding the risks of the materials that they present, whether they're critical or non-critical, and then also understanding how those ingredients or those components interact with your product that you're going to be selling to people. Basically, the whole gamut of understanding product and process risk. But we extend that out to the suppliers because ultimately we're responsible. So we want to make sure that suppliers are manufacturing with good practices, that they're actually checking the things that they're supposed to be checking, meeting the criteria that they're supposed to be checking, and they have all documented objective evidence to support this. In this industry, it's obviously different, even though there might be liability to the license holder, which might be a manufacturer, a vertical operation, or anything like that. It doesn't always transfer over to, say, a state laboratory. I imagine it would be very hard to sue a state laboratory who's responsible for providing results on release of product that's going to be going out to the market. But with that said, that's currently what we do now. That's not really something that's sustainable. This industry will morph and evolve into the way other industries are that we come from, to where you will have entities that can be held responsible in some respects. And surely, if you're a provider of components or raw materials, that's a private ancillary company, you can be, like Adam was saying, still be held liable. And even if a court decision isn't, judged against you, there's the whole, PR, nightmare that you probably be presented with, of having to repair your image in an industry that's so new and so competitive that the damage to that could be excessive. Besides, the cost could be, could destroy your company itself.
Yeah, I wanted Adam to offer thoughts on that too. That's kind of my follow-up question. Because Adam, you alluded to, regardless of the outcome of the case, or once the company is accused of something, you still have your legal battle and you have your, PR nightmare, as John just said. So, um, can you just offer some thoughts on this, how you've guided clients to really overcome from cases like this?
Yeah, it's tough because you have to, going into any sort of business, you have to be aware that there is a potential for lawsuits to come down the pipeline. And in this industry, it's different from a lot of others. In most industries, whatever it might be, trucking, pharmaceutical, selling T-shirts, right? You can ship your product across the country, across the world, right? You can ship it anywhere, and so you can build a national or international brand. People do it on Instagram; they build their own brands. But in this industry, unless you're talking about hemp-derived CBD, if you're going to be focusing on adult-use cannabis, you are a state-based company. You can't ship your product. So if all of a sudden lawsuits start coming down the pipeline and you're swept up in one, as John said, it's not just the cost of the litigation, which can be expensive and time consuming, even if you win. A lot of my cases will go on for 2, 3, 4, 5 years. I have a case that's 10 years old right now, and it's still going. But separate and apart from the legal costs, you're trying to break in or establish yourself in an industry that is uber competitive, that is state-based. And so you're fighting with everyone else within your state for a very small piece of the pie. You can't try and bolster your business by expanding into Nevada if you're in California, or expanding into New Jersey, or branching down into the Carolinas if you're on the East Coast. You can't do it. You're stuck in your state for the time being until the feds deschedule cannabis. So understanding that and making sure that you've done everything possible to try and avoid litigation, and then also get out of litigation as soon as possible, that goes a long way to protecting your company from financial damages.
And to just one question I would present to any cannabis related company is, I would say reach out to a PR crisis management specialist, ask what their hourly fee is and what their cost would be from their experience as far as dealing with crisis, and really take that into account when you're deciding what you want to do and setting up your company, because from my experience, the cost can be astronomical, surely as much as any legal proceeding in some respects.
Yeah, that's a good point. And before we move on to questions, Adam and John, do you have any final thoughts on any of the topics that we covered?
I don't, but I'll defer to Adam since this is really his scope of expertise in this respect.
I would just, and Bethany, I laughed when you said, those nightmares that I present to everyone. As a lawyer, we are reactive in a lot of instances. John and your company are the ones acting proactively in a lot of cases to try and help avoid needing my services. I would just tell people, when you've started up your company, make sure that you've got those types of quality assurances in place. Make sure you've hired a good general counsel as well, and be aware of what lawsuits are pending, and be cognizant of the fact that products liability, encompasses a large number of claims. And within this industry, we're not just seeing products cases, sitting by themselves. We're seeing products claims tied in with RICO claims. And you need to understand that just because, one specific judge or court rendered a decision, of X, that doesn't mean another jurisdiction is going to come down with the same decision. So you just need to be very cognizant and, cross all your T's, dot all your I's, and really do everything you can so that if and when litigation does unfortunately land on your doorstep, you've got enough evidence and documentation there to hopefully get yourself out of it as quick as possible.
Yeah, thank you for that.
Bethany, I'd also like to just add one point on that. I think it's critical for people to understand, especially licensed owners and people that are deeply involved in this industry, that when you look for subject matter experts that are experienced, whether it's legal or whether it's, you know, services like we provide or anything like that, somebody who's only been involved in the cannabis industry is not always the best course of action. You might think that way and say, well, you know, they've been in the industry 5-6 years or whatever. But really, when you're talking about certain aspects, practical experience and how to apply that practical experience most effectively is really the critical element, and why we value it, you know, specifically in our industry, why we value experience and age and things like that. Because, you know, if I have only done practices within cannabis space, which is very fragmented and undefined in a lot of respects, I probably have not had a lot of practical experience on what's coming down the road. So I just tell people that all the time, that really don't get so enamored by somebody having 5 or 6 years of cannabis experience if they don't have other experience outside of that scope of industry.
It's an interesting perspective, and I appreciate that. So I want to open up for questions. Let me make sure everyone can come off of mute. Okay, so everyone should be able to come off of mute if you wish. I'm going to kick it off with just making sure that we have a solid understanding of action items to take home, some homework. So what can my company do right now? Not a whole lot of investment, something easy. Just wanted to get some homework for the team.
So I'll go first, and then I'll let Adam go. Really, in short, it's really about identifying risks and mitigating or eliminating those risks based on what the criticality is. So it really comes down to understanding all the things that we've talked about within your organization, and really understanding risk management and how to identify those risk points and mitigate them or eliminate them.
And from my perspective, I would say the two easiest things to do are, one, understand the regulations within your state, and to a certain extent, make sure that those regulations are applied uniformly. Some, you know, municipalities may have certain tweaks to those regulations, but understand those first and foremost for where your company is located. And then two, just document everything you do. You know, telling me 3 years after something happened, I did X, and you have no documentation to prove it, puts me in a very difficult spot to try and defend your actions. So document everything and keep that documentation for whatever period of time it is, 5 years, 3 years, whatever you set up, but document everything.
Very good. Any questions from any of our participants?
Hi, this is Zach Helms. John, Bethany, thank you very much. It's another really informative panel you've done here, and Adam, thank you too. This is going to be awfully specific to the type of business that we engage in, but I'm curious how a company like ours, who deploys their brands through contract manufacturers, might be able to additionally mitigate risk. And I guess that question's for any one of the three of you who might have some insights on that. Obviously, we can look and make sure that those manufacturers are doing appropriate vendor qualification, that they're GMP certifiable, those sorts of things. But is there anything additional for a company who licenses brands to go to market but doesn't actually ever take ownership of any cannabis? What else can we do to protect ourselves?
So I think from Zach, thank you for the question. I think from a quality perspective, it's you can do things like ensuring that a company is certified, ISO qualified, or anything like that. But it's really the level of scrutiny that you apply to that vendor, how robust your qualification process is. Do you? And I'll just give some examples here. I might. If I have a supplier qualification program, I might find a new supplier and defer any type of on-site assessment for them because they have this certification, but I might need to be on-site, boots on the ground in a year because I need to verify that they're doing what they say they're doing. But in the initial aspect, I can accept them because they provided their certification. I know that they're meeting certain standards as per these non-biased registrars that are out there. and they have provided maybe some other objective data, SOPs and things like that, that show me that they have these systems and processes set up within an organization. So I can kind of take that and say, all right, that mitigates my potential risk for the time being, but it's a non-critical component, so I don't need to be on site right away, but I'm going to be there later on. So I guess my point would be that it's really about the robustness in which you evaluate or hold suppliers accountable, which can really be the defining criteria or element there of mitigating risk for you as a person who contracts out these manufacturing processes.
Yeah, I would say, Zach, you know, if you're contracting some of these things out, that making sure that no modifications are made to the product by the person purchasing it. You know, it sounds funny, but people do it all the time. And you know, while a manufacturer has a non-delegable duty to produce a product that's not defective, that responsibility is always gauged when it leaves the manufacturer's hands. So you just want to make sure that they're not making substantial modifications. You know, ultimately, modifications like that, you know, from the original condition that are made by a third party, which can then render that product unsafe, aren't the responsibility of the original manufacturer. But, you know, you don't want to get into that situation where you're having to just then litigate that. So that would be one thing I'd say.
And you know, to piggyback on that, Zach, if you do end up in a scenario to where you need to modify that, because that happens very often in industry, you need to have that defined and agreed upon, and basically, as Adam said, objectively documented, that you're aware of the certain risks that you're doing when you're you know, altering or differing the product that you're getting from the supplier and then putting out to the market. Those are all pretty standard practices within other industries, but surely not within this industry.
That's wonderful. Thank you both.
Any last questions? We just have a few minutes. Okay, I wanted to, of course, you're welcome to reach out to John or Adam for any further questions. This recording will be available on the QA Canada website, and we'll publish it out on LinkedIn as well. Any suggestions for other forums are also welcome. Thank you so much for your participation today, everyone.
Thank you.
Everyone. Thank you, Bethany. Thank you, Adam.
Thanks, guys.
Have a great day.
You too. Bye.
Good. Bye.
Bye.